For today's Child Welfare Legal Academy, the topic is school discipline and youth in foster care. And with us, I think you'll find we did identify some of the best experts in our state to cover this topic in the broadest spectrum we could put together. We have with us today Brad Bryant, who is the Executive Director of the Georgia Foundation for Public Education, the Georgia Department of Education. Also on the far end, Mr. Quentin Fretwell, who is the Director of the Department of Student Relations with DeKalb County School District. And in the middle, Rob Rhodes, who is the Director of Legal Affairs for Georgia Appleseed Center for Law and Justice. Their complete bios, which I have not done justice to, are provided for you on the back of the materials that you have. You also have copies of their PowerPoint presentations. And so, more important that you hear from them, and I'll turn the program over to Rob. Please join me in welcoming them.
Thank you very much, Melissa, and thanks in particular for your leadership of the Barton Center. We at Georgia Appleseed have partnered with the Barton Center and with Voices for Georgia's Children, in particular the last several years, in connection with a rewrite of the Georgia Juvenile Code, which as we speak is moving its way hopefully through the General Assembly to passage this year. We will expect a vote on the House floor tomorrow, so if you have any influence with your representative in the House of Representatives, contacting that person and urging them to vote yes for House Bill 641 would be greatly appreciated. I'm going to talk today about what we call effective student discipline, keeping kids in class. This will focus on the larger general education population. We know that the foster care population, while a small segment of the public school population, very often has very poor outcomes educationally. We are, in fact, yesterday working through the leadership of the law firm of King and Spalding here in town, in the early stages of a detailed project to assess the educational stability of foster kids in the public school system and to come up with an assessment of that, because Georgia Appleseed always wants to go into these sorts of things using an objective analysis and looking in the data, but to the extent that we see areas that can be improved to improve educational stability for the children in the care of the state, we'll be coming out with some recommendations hopefully mid-year. Let me tell you what I'm going to talk about. And first of all, I usually don't spend too much time on this because I tend to be preaching to the choir in most of the situations when I'm talking about this, and that is why Georgia Appleseed is concerned about that. We're committed, along with a number of other groups around the country and in Georgia, to doing away with ultimately what people refer to as the school to prison pipeline, and to establish what we like to refer to as the school to success pipeline. Most folks are certainly aware of the importance of the completion of at least a quality high school education as a prerequisite to any sort of economic or other success in life nowadays at a bare minimum. And so kids who, for whatever reason, fail to finish high school are more than likely going to, at the very least, have a life of very difficult economic consequences, and often find themselves in trouble and ultimately in the juvenile and adult court system. It's sort of intuitive that one would think that if you're not in school because for whatever reason, but in particular for disciplinary actions, that you're not learning, and that's going to impact your capacity to ultimately succeed in school. It is helpful that the Georgia Department of Education last year actually did a quantitative analysis of the data, which ultimately concluded that if a child misses more than 5 days for whatever reasons, excused absence or unexcused absence or disciplinary action, you can see a clear decrease or adverse impact on academic performance. So it's always nice when the data sort of confirm your predispositions. The other thing that I like to talk, and I don't really know who we have represented here. Somebody just asked some questions in terms of your professional experience. How many of you are in private practice and would be representing potentially students in disciplinary action or juvenile court? How many folks represent child welfare agency or other state agencies that deal with these kinds of issues? How about people representing schools, school districts? Okay. I probably missed some categories, and I apologize, but I get a sense of that. So one of the things that we mention here is that our intent in doing the study that I'm going to talk to you about is to do an objective, fact-based, data-based study. And we don't come into these things with any particular bias. And we clearly recognize, and today, if you read the headlines about the tragedy in Ohio, I guess it was, where a student apparently shot some other students, that brings to a head, and all the way back to Columbine, those things, those incidents, tragedies, bring to a head the importance of what I'm going to talk about, and that is that the people who are in the school systems on a day-to-day basis, the teachers dealing with the children, the principals and assistant principals who deal with disciplinary issues, face an enormously difficult challenge. And it's because they're constantly having to weigh two potentially conflicting considerations. There is a delicate balance between the collective need, the collective absolute requirement that all children in the school have a safe environment and an environment that's conducive to learning. On the other hand, we believe, and we think the Georgia Constitution requires, that each individual child at least have a reasonable chance to get a quality high school education. And if you consider that they are in fact children, then they're not always going to be perfect. There's going to be acting out. And so it's the balancing act that the teachers and the principals are required to do on a day-to-day basis to try to assure the safe environment, the quality learning environment for the collective student body, and while balancing that with a real meaningful effort to make sure that each and every child has a reasonable opportunity to get an education, is that difficult task and that difficult job. I talked to someone the other day who was putting it into context, and they said, well, she deals with parents a lot, and a lot of parents of the good kids, my kid never gets in trouble, say, my kid deserves a chance to learn. I don't want my child's education disrupted by these kids who are messing up, who are disrupting, who are taking the teacher's time. And she always says, well, that's fine and good, but remember, how will you feel if you were the parent of that kid? Would you, of the kid who is acting out, but who still deserves an opportunity for education? So that's the balance. Why do we get involved in this? Well, 2 or 3 years ago, we became aware that there were being studies done in other portions of the United States, in particular in the Southeast, where organizations were taking a look at student discipline practices, triggered in part because of concerns about zero tolerance policies that had been put in place in the 90s, which were sort of a get tough approach to student discipline for certain types of activities. And some groups began to question whether that get tough attitude might not be having unintended consequences and in sort of speeding kids through the school to prison pipeline. Florida's the Advancement Project, which is an element of the NAACP, did a study in Florida. They characterized the disciplinary situation in Florida as a school discipline crisis. We have a sister center. Georgia Appleseed has a sister center called Texas Appleseed that's done a detailed studies of the situation in Texas and documented substantial use of exclusionary discipline and raised question as to whether or not that was appropriate. Louisiana, in particular in the new school district in New Orleans, characterized the disciplinary situation there as a human rights crisis. And just to be sort of equitable here and not focus on the Southeast, the city of Philadelphia was also studied and found some extensive use of zero tolerance policies with negative effects on students. So what did we do? We decided, well, it was time to do that kind of an analysis in Georgia. No such statewide comprehensive analysis had been done. We knew that schools are required since the year 2000 or so to submit detailed disciplinary data up to the districts. The districts were then in turn required to submit those data to the Department of Education. So, and that includes on a student by student basis the reports of each individual's history in terms of the types of disciplinary incidents involved, the extent of disciplinary action, whether it be in-school suspensions, out-of-school suspensions, expulsions, referrals to alternative education settings. All those data had been reported for year after year after year. So we've worked with the Department of Education and were able to obtain from the Department of Education a comprehensive, huge database in coordination and cooperation with the Department of Education. We have in our possession and under the management of a volunteer from the Ernst & Young office here in Atlanta, millions and millions of data points. We have the individual disciplinary history of each individual student, 1.6 to 1.7 million per year for the last 8 years now. And that allows us to do a lot of detailed analyses. We don't know who the students are, and we are subject to a confidentiality agreement, so we're very mindful of that. But we can do a lot of good analyses with the data that we have. We also decided that it was important to talk to those folks who are faced with that delicate balance day in and day out. So with the help of, again, the department and with some of the folks in Atlanta who work with school boards and school superintendents around the state, we were able to get access to 12 school districts from all over the state and go out and talk to school superintendents, deputy superintendents who had disciplinary responsibility, principals at all levels, high school, middle school, elementary school, teachers at all levels, school resource officers who, as you know, are the policemen whose primary beat are public schools. We talked to juvenile court judges and their interface with the school systems. We talked to probation officers. We talked to advocates for kids in disciplinary processes and those who advise school boards. We had great volunteer assistance. Michelle here on the front row is one of our volunteers who worked in the process. We had 100 lawyers from around the state going out and talking to these folks and collecting information, and that was all compiled as part of the report that we issued last year in June in a voices from the field summary of all these comments. We did some analysis. We've done some research on what we think key elements are of an effective student discipline system. And one of the things that we found in our work talking to folks was that perhaps one of the most controversial issues out in the field was the effectiveness of zero tolerance policies. We had folks who were very committed to education, very committed to assuring that their students graduated from high school, who swore that zero tolerance policies were appropriate and worked in their school systems, and they were not about to hear objections. We had just as many people on the other side who said that there were so many unintended consequences and it had a negative impact, it was not working in their systems. And so we don't know. You know, we report the information that we have. We certainly have some views about that, but what we did in our report was call for a conversation. We said, here are these disparate views. Districts, you're required every year to take a look at your code of conduct. We challenge the districts to take a close look at your zero tolerance policies in that yearly evaluation and see whether you think it's working. Can there be changes that could be made to make it more effective? Or do you need to do away with zero tolerance policies altogether, except to the extent that they're mandated in a limited way under state law? We then had a call to action, and I'll talk to you a little bit about that at the end of this presentation. But I want to talk to you about today, and I hope it's not too enervating because I'm going to be talking about data and showing you a lot of numbers, and I'll try to put it into context. But the whole purpose of this is to show you the kind of data that we have and the opportunities that these data provide to do assessments. I say all the time that data are just numbers. All they do is start a conversation. And as we go through here, I caution periodically not to rely too much on the numbers because you got to get behind the numbers. You have to understand what's going on. And I may give you a couple of examples of situations where the numbers tell you one thing, but then when you get behind them and you find out what's really going on, something else is there. But at least the numbers started the conversation. So the data I'm going to show you today are based upon 7 years of analysis that we did in cooperation with our Ernst & Young partner. Ernst & Young is working diligently. We have the 8th year worth of data from the 8th year data from DOE, and as soon as my colleague at Ernst & Young finishes moving from one house to another, he's going to finalize integrating that 8th year into the data. We'll show you 7 years worth of data, and hopefully in the next couple of months I'll be issuing a supplement. What we wanted to do first was try to see where Georgia stood in the context nationally We had to rely upon, when we did this study, data in 2006, because the only data that we found that we were comfortable with on a comparability standpoint was data reported by the Office of Civil Rights of the Department of Justice. And they are kind of 5 years behind the power circle, so power curve. So we had 2006 data, and we took a look at it, and our conclusion was that Georgia ranked 10th in terms of the OSS rate, and that's a term we'll use throughout the process. That means the number or the percentage of kids in public schools that got at least one out-of-school suspension during a calendar or school year. So South Carolina led the pack in 2006 with 13.9% of the kids in South Carolina getting at least one out-of-school suspension. Georgia was 10th in that analysis with about 10% using these data. As you can see, most of the high level, these states were in the southeast U.S., indicating whatever you might infer from that, maybe some cultural approach to discipline that might not be elsewhere, although you see Rhode Island and Delaware in there for some reason, so I don't know what small New England states have in common with these other states, but it is interesting to know. Just to put this in context, those states that have what might be recognized as very high quality public education systems, Minnesota, Iowa, Vermont, all of which are very different, obviously, than Georgia, you see these average as OSS rates at about 3 to 4%. So that helps you put it in context. Key findings in school year 2009-2010, which is the latest data that I'll be talking about today, we saw a slight reduction down to about 8.1% of the kids in the K through 12 system getting at least one out-of-school suspension, and that's across the statewide. One of the key findings that we made here was that the use of exclusionary discipline is highly variable among school districts, and that, of course, shouldn't be surprising. We have 180 plus school districts in Georgia, from, I think, Chickamauga City might be the smallest with 200 or so kids in it. Gwinnett, the largest, 167,000 kids. So as you can imagine, with resources and other factors, you're going to see some variability. But so that we did see, as you'll, and I'll have some slides here to talk about that, but we did see some school districts where out-of-school suspensions was extraordinarily rare, 1 to 2% of the student body, and then others where you saw numbers reaching as high as 19, 20, and 25% during the period of record. At least, so in a school district, 25% of the kids getting at least one out-of-school suspension. So the good news, it's a bad news, good news story. The bad news is you would hope that there wouldn't be that level of variability, because you'd hope that kids throughout the state would have at least reasonably comparable risks for being suspended from school. The good news, to the extent that you can characterize anything, is that by looking at the data, you can see where hotspots or where potential concerns may be with a potential overuse of out-of-school or other exclusionary disciplinary actions, and so that if you were going to focus an assessment and potential responses to this, you at least know where you should go to get the biggest bang for your buck. We did an analysis. Again, one would think that the more kids are out of school, the less likely they are to succeed, and therefore that's, again, sort of intuitive. We looked at the data for the 7-year period in question. We identified those school districts that had the highest out-of-school suspension rates over the 7-year period. There were about 17 of them or so. And we then identified the out-of-school suspension rates at the lowest level in districts, and again, there were 17 or 16 of those. And then we took the average graduation rates for those districts, and and then we charted it here. The green line reflects the reported graduation rates statewide during this 7-year period. The blue line are the graduation rates for the schools with the highest out-of-school suspension rates, and the red line are those with the lowest. And again, intuitively you might have expected this, but the data show that those schools that have the highest out-of-school suspension rates typically are well below the state average and substantially below the high school graduation rates of those schools that have very, very low out-of-school suspension rates. We're careful to say that we don't claim any statistical causation there. It's purely a correlation. There are a lot of factors that weigh into that. We don't say that if you automatically change your out-of-school suspension rates, you will necessarily raise your graduation rates. But it's clear that that is at least a factor that needs to be considered. We took a look at some other factors, similar to some studies that have been done around. One of the reasons that people talk about out-of-school suspensions as being important is because of the need to maintain school safety. And again, as I mentioned earlier, sitting here today with the tragedies that go on periodically, you can certainly understand that. So we took a look at the data and tried to assess those, the nature of the disciplinary incidents that trigger the out-of-school suspensions and characterize them as either violent or non-violent. And we don't mean serious and non-serious, because certainly there are a lot of non-violent behaviors that should be subject to discipline, drug use and other things. But this was an attempt to, at least in a gross kind of way, try to figure out, how much of out-of-school suspension was being used to sort of deal with overtly violent behavior where you would assume that there would be some concern about safety. And about 70%, 69% in 2010 of the out-of-school suspensions were given for incidents that we characterized as non-violent. And as I said, we clearly are not saying that they're not important. We're just questioning whether, given a 2 or 3 day out-of-school suspension for casual use of drugs on the campus, is the best way of dealing with that problem. I would say it provides 2 or 3 days for people to continue casually using drugs and without very much other benefit. Brad, well, no, that wasn't a private conversation. In an earlier conversation we were chatting earlier, he mentioned, but one of the other things we did was we look at, if you're involved in the school system, you're aware that when these data are reported, they're required to use an incident code that describes what the nature of the disciplinary incident was that gives rise to the disciplinary action. And there are 24, 25 of these, all the way from fighting, from theft, and various other specific items. What we found was with increasing regularity, and in fact over 61% the last 2 years of the disciplinary incidents, where only one code was used. The code was number 24, other disciplinary incident. So we've raised some concerns with the department and are in some ongoing discussions about why is that happening? Is that appropriate? We understand, in talking with Gary McGibney and who works closely with Brad, that there are some relatively benign reasons that might occur. But we also, just in total honesty, believe that there are some perhaps not so benign reasons. In particular, we think a lot of these things occur.
As does he.
What I call the kid has sort of gotten on my last nerve situation, where, there is no specific designated code for disrespect, and we think that that's something that needs to be evaluated. So we confirmed what everybody has confirmed in these studies, that there is racial disproportionality statistically, and we have about the same incidence on a statewide basis as you see in almost every state that's looked at this. The black students are about slightly over 3 times as likely to get an out-of-school suspension as students of other ethnic or racial groupings, and that's pretty consistent throughout the state, notwithstanding the variability of the use of out-of-school suspensions. You do see, even in those situations where districts have low out-of-school suspension rates generally, the black students in those school districts tend to have disproportionately higher incidences of out-of-school suspensions. See other categorizations. The department is required to, school districts and schools are required to report up to the department on other subcategorizations of students, and you do see some of those triggering an excess of out-of-school suspensions compared to others. Kids who are eligible for free and reduced meals consideration in the school systems, which we use typically as a surrogate for poverty, have about a 2.5 higher chance of getting out-of-school suspensions or expulsions than the kids who are not so eligible. English language learners have a slightly more than twice the chance of getting out-of-school suspensions, even though Hispanic students do not. In general, Hispanic students have a less than what you would expect based upon their population in the student body, and that's even if you go down to, in general, to most school levels. But English language learners, on the other hand, do. Out-of-school suspension rates for special education students are slightly above 1.5, which experts tell us is the point where you would want to ask questions. Doesn't necessarily indicate there's a problem, but if you have a risk ratio of 1.5, which means that you have a 1.5 greater chance than other people who are not in this category, that at least raises a question. So it's still a little over 1.5 for special ed kids, students with special needs, and that is despite the fact that, as many of you know, there are substantial protections for kids in this category before you can actually impose a cumulative suspension in excess of 10 days that requires some preliminary assessment to see if the behavior is a manifestation of their disability. So even with those protections in place, you do see a slight increase on a statewide basis for special education kids. So I'm going to talk about data. I'm going to give you some examples of inter-district variability, one district versus another, some examples of intra-district, in other words, differences of school systems and school clusters within districts. And I've chosen several school districts from around the state, not to pick on them because I could have chosen a number of others, but just because they present some evidence of variability or some of the phenomenon that I think it's important. As I said earlier, data is just a starting point. It's a basis to initiate a conversation. It's not an end point. I have what I call a tale of two districts. This is a good example of inter-district variability. Houston County, Warner Robins, and Bibb County, Macon are immediately adjacent to each other. They share a border. The I-75 travels through there. Anybody who's driven to Florida, you go through Macon, then you go through Warner Robins. This is the demographic information. About the same size. The Houston County school. These are the school district information, not general population. So you see that Bibb County is substantially higher African American population in the public school systems than Houston, and has a substantially higher free and reduced lunch eligibility situation. As you can tell, the average graduation rate in Houston County for all students is about 82.6%, which is higher than the state average for all students, and compares to 63.4% graduation rate in the Bibb County area. For African American students, the Houston County, again, obviously lower, and obviously that's a concern, but it's higher than the state average. Whereas only 59.9% of African American students graduated in 2010 in Bibb County. So this, and here, these are the out-of-school suspension rates comparing the state average to the Houston County average out-of-school suspension rates on the district-wide basis to the Bibb County base. Bibb County has, and I hope, to the extent there's anybody here from Macon and is concerned, we do note that they've changed administration in the Bibb County school system. There's a new administrator. There's a new deputy over there who's very committed to changing issues. We don't have the 2011 data, but historically, Bibb County has presented significant difficulties and challenges here in managing student discipline and in student outcomes. Houston County, on the other hand, as you can tell, has an extraordinarily low out-of-school suspension rate. Usually high school by high school, but basically in Houston County, the high school out-of-school suspension range there is from about 0.5% to 5.2%. Middle schools about 0.2% to 6.6%, and those compared to state averages of 14% and 12%. And indeed, the two high numbers there, the relatively high numbers, 5.2 and 6.6, are the alternative schools in those locations where you might expect a higher disciplinary action. So very extraordinarily low out-of-school suspension rates in Houston County. On the other hand, Bibb County, Southwest High School in Bibb County in 2010 suspended at least once more than 50% of every child in that high school. And other high schools in the area had, not quite as stark, but still rates that were as much as twice, more than twice the state average of 14%. Here are the middle schools in Bibb County. Again, several of the middle schools have numbers that are 2.5 to more times the state average. We do have some that are closer. Again, typically, this is just the start of a conversation, but the Howard and the Rutland schools have significantly more diverse, ethnically diverse populations than do the other schools in that. Elementary schools, it's almost shocking that some of these elementary schools have, like King Danforth Elementary School, where the statewide average is 3 to 4%. The King Danforth Elementary School, 24, nearly a quarter of the elementary school kids are getting out-of-school suspensions. Clearly, there are issues to be dealt with there, and we're not going to solve those problems. It's just an effort here to show you what the data can tell us. And finally, I'll stop jumping on Bibb. It's just it's because we know there are a lot of good people over there doing a lot of good work. But expulsion is a relatively rare circumstance in Georgia. Maybe between 3,000 and 4,000 kids every year get expelled statewide. In 2010, 10% of those kids came from Bibb County. Here's some closer to home here in Atlanta Public School System in Fulton County. What this is an effort is to show a little bit about intra-district variability to some extent. But here, if you looked at the APS versus the Fulton County data compared to the state data, you would note APS has historically had relatively high out-of-school suspension rates, but you do see an apparent downward trend. So you raise your question, are there things going on in the Atlanta public school systems? Are there efforts to deal with this? So you can see that downward trend, which is a bit of information. Look at Fulton County. You see fairly static, although a slight increase in out-of-school suspensions. I don't know if that's statistically significant or not being a statistically significant person myself, but you see those data and you would say at the outset, well, gee, if I was going to really focus on issues here, I'd take a look at APS before I'd worry too much about Fulton County. But you'll see in a minute that may not be entirely correct. Anyway, here are the state, here's some high school numbers in APS. And again, you see, this is Washington High School, which a couple of years ago did one of these things that high schools are trying to do, and that is break down into smaller academies with a focus. It apparently hasn't affected their out-of-school suspension rates very much because they have the highest there. The other interesting thing, which again, this is data, and we have to answer why this is happening. But Carver did the same thing. Carver has a school of technology, they have a school of art. The only thing I can figure out is artists are much easier to deal with than technologists because of the variability there. Those are about the same size schools, so they're similar and they're similar demographic populations. So my guess is, and it's purely a guess, is that it's a leadership issue. There's something going on at the Carver School of Art from a leadership perspective that deals with these issues. Yes, ma'am. Okay.
The School of the Arts is much more selective in who they choose, that you have to apply to that school rather than technology takes more in-zone students. And also with that, Grady and North Atlanta are much more diverse than the other schools.
That's correct.
So, but Carver Arts is a very self-selected type of population.
Yeah, even though the demographics are similar, racial demographics are similar. That's a good point. And then also you see that Mays, Grady, and North Atlanta have relatively lower rates. But again, as she pointed out, you do see a much more significant diverse population there. Here's the situation in Fulton County that I was referring to earlier. If you just looked at Fulton County data on the average, 7, 8, 9, pretty much close to the state average, it wouldn't jump out at you as if I was going to spend resources but many of us in this room know that Fulton County is really two counties, South Fulton and North Fulton, and the South Fulton County high schools, which again are predominantly African American, ranging from 95 to 100%, have relatively high out-of-school suspension rates. And then if you go to the northern reaches of Fulton County, you see extremely low numbers there. So again, this is just a point of saying you can't, numbers, you have to go behind the numbers and you have to assess what's going on. since we had representatives from DeKalb, I didn't want have him felt left out in the system, so I put some DeKalb numbers in here. You see DeKalb compared to the state numbers. You see an apparent downward trend over the last several years, which again would warrant further assessment and evaluation. Decatur, much smaller school system, 3,000 to 4,000 kids in Decatur public schools and 90+ thousand in DeKalb. So it's a totally different system, but you see a low out-of-school suspension rate in Decatur. Here again, you see again a rough correlation between schools with a substantial majority-minority population of African American students, with Towers leading the pack in DeKalb, versus the more diverse schools, especially in the Dunwoody, Cross Keys area, with much lower out-of-school suspension rates. Middle schools, again, you see that sort of dichotomy there, and then you have a couple of elementary schools in DeKalb County where you would think that there might need to be a focus, and maybe one of those maybe even closing, I think. Muskogee, and I know the data can get a little enervating, but here's another situation. We do work a lot in Columbus, and you can see, again, Muskogee County is one of those that has historically had high rates. We see a downward trend there. Something's going on in that school. They have a new school superintendent who's been in there for 3 years and has quietly replaced 50% of the principals in the Muskogee County public schools over the last 3 years. Not with a high-profile thing, but you're beginning to see, I think, some impact there. And again, here, Muskogee is a county where there's a pretty clear delineation between the parts of the town and the schools that are predominantly African American, and those parts in particular North Columbus where you have a more diverse population, and these schools generally follow that pattern. So those are the data, and again, we're not jumping on any of those school systems other than these are examples of data that we have that are able to focus us on issues that we think can be helpful in assessing the situation. So what has Georgia Appleseed done? We've issued our report back in the June of 2011. And one of the things that I always say is since I was the primary author of that report, and it was a heck of a lot of work, let me tell you, not only mine, but that of the volunteers and others who participated, that I don't want it to be one of those things that becomes a convenient place for your coffee cup to rest on your desk as you're looking at other things. We want to make sure it's a living document and that it leads to further action and that it provides a resource and information and inspiration, hopefully, to others to work with us to affect change. One of the things that we're doing is what I'm doing right now, which is presenting these data at fora around the state. Sharon Hill, who has joined us and is also making these presentations with me, and I have spoken in Warner Robins and Savannah and Macon and Columbus and elsewhere in Valdosta and other places around the state, trying to bring this word together and trying to raise consciousness and encourage people to try to take these data and do something with it. So we'll continue to do that. Today, if I count the room, will bring us collectively to over 1,000 individuals that we've touched with these presentations. That's the good news. The bad news is I made a mistake of setting a goal of 3,000 early on, and I'm working to achieve that. So to the extent that your organization would like to hear more about this, Sharon and I have PowerPoint and we'll travel, so we're happy to talk. We're working on some policy changes. As I mentioned earlier, we've talked with the Department of Education in particular about the use of the other category as something that we think is worthy of evaluation to see if there can be some policy changes or at least some guidance that would help the teachers and principals and others and when that can be used and what the alternatives are. There are other policy issues that we will be talking around, and I'm sure we'll have at least a friendly ear. We may not ultimately agree, but we have good access and good cooperation with DOE. Legislative changes, we looked at the Title 20, which is where all the law is for the most part with regard to student discipline actions. It's a pretty good law, really. I mean, it's fairly modern. It's not like the juvenile code, which was 40 years old when it was initiated and had a lot of patchwork changes that really needed to be you really needed to start over again and create a whole cloth document. Title 20, if implemented, is a fairly good piece of legislation. So we're not proposing any sort of overhaul there. However, we do have some suggested things that we would like to see the legislature deal with, hopefully in the next session. One of which is the consideration of whether or not it would be appropriate for schools and school districts to make a more transparent notification and publication of their disciplinary activities and record, much in the same way that currently schools are required to report historically AYP status. This will be changing now under the waiver, but I would imagine that schools are still going to be required to give notice to the public and to their parents and their students of how they're doing under the waiver criteria, and we would suggest that perhaps some element of disciplinary criteria should be added to that. For those of you who are involved in student tribunal processes, you know there was a case last year which basically concluded that that subpoenas issued by school boards were not enforceable. We're trying to pass a law that would establish enforceability for school board subpoenas in cases involving student discipline. We have a real concern about a law that's not in Title 20, but it's in the criminal code, which basically prohibits the disruption of a public school bus, or school bus stop. That is, for many kids being referred from schools to juvenile court, that's the #1 count that's cited, disruption of public schools. And it's a relatively vague statute, and we think it can be perhaps overused, and that there are other more specific criminal prohibitions that can be used if you really got something serious enough that you want to send a kid over to juvenile court. The final thing that we want to work on and are committed to work on are what we call local change initiatives. We're committed to work with local parent groups, community groups, local school districts to take what we've learned and what we have access to in terms of our data and the level of knowledge that we have about other things that seem to work in other locations, and work as a partnership and a collaborative to try to attack at the local level a situation where there appears to be an overuse of out-of-school suspensions or other exclusionary discipline action. That could be at a local school level, it could be at a school cluster level, it could be almost anything, but we think it's important that in this situation, given the way Georgia operates and the significant reliance upon local control of public school systems, that the real way to begin to address these challenges is through increased parental involvement, community involvement, and focus at the local level to see if we can get some victories, get some changes, and establish some pilots that can be used by others, and we're committed to do that. Finally, let me just mention a couple of things, because this is just intended to trigger a later discussion that we might have, but some of the things that we are talking about in response to questions that we get in situations like this, especially from educators, is, what are our options? I mean, we got kids who are acting up. If we can't put them out of school, as a final resort almost, what can we do? How can we deal with this? You can't just tell us that out-of-school suspensions are bad and not provide us with other alternatives. So here are just a list of a few which we'll talk about perhaps later on, but that we've identified that can work. One is what I call the superintendent or principal checkoff, which is nothing more complicated than a superintendent, or in the case of a school, the principal saying, I'm concerned about the number of out-of-school suspensions that are coming out of this location. Before you propose an out-of-school suspension in excess of 3 days or 5 days, whatever it is, you have to come to me and explain it and get my checkoff and approval for it. We've seen that occur in some places, and as you might imagine, just in sort of the corporate world, if your boss has to sign off on something, there's a tendency for there to be almost an automatic or an initial reduction at some level of the out-of-school suspension. I talk about beefed up ISS or ISS on steroids. In Connecticut, they passed a state law, and Maryland's considering something right now that makes it very difficult for the school systems to impose out-of-school suspensions except in rare circumstances. Now, I don't have a big hope that the Georgia General Assembly is going to put that kind of restriction on our local school districts, but what Connecticut found was, after the school district sort of fought it for a while, was that they then implemented a beefed up in-school suspension program with certified teachers and a meaningful requirement that work be done and no messing around in class when this was going on. And what they found was that the recidivism rate dropped off markedly. Data showed that the kids, and the reason for that, and I'm not sure that this is the right rationale for stuff, but the kids hated it. Kids did not want to go to in-school suspension when they had to do the work and when they were under the direct supervision of a teacher and where they weren't allowed to text and they weren't allowed to sleep. And they called it, it's just like being in jail. So rather than do that, they conformed their behavior a lot more. And you wonder whether that kind of environment, recognizing that there are associated costs and resources that have to be allocated to it, makes some more sense than putting a kid out unsupervised without much incentive, especially a kid who didn't want to be in school in the first place. The important issues of early identification and intervention. Are we doing as much as we can under the RTI or programs that are response to intervention programs that are in public schools on the books? Are we in fact dealing with those kinds of early intervention programs with fidelity? We have a progressive disciplinary practice requirement in our public schools codes of conduct, which means you're supposed to start at the lowest level of punishment and work your way up, and that's fine, but concomitant with that needs to be an assessment of why these early level interventions aren't working. What's going on in the kid's life so that you can perhaps find a response to that and apply resources to it before you get to the out of school suspension level. School climate initiatives, I'm speaking tonight in DeKalb County with Gary McGibbony on the same issue we were talking about today. He's going to talk about PBIS, or Positive Behavioral Intervention and Support Systems, which are a framework for basically changing the overall approach that a school has to its discipline approach, to an approach that, while it keeps negative discipline in place for the appropriate situation, it has positive reinforcement and develops an overall school climate where they teach kids to behave and reward positive behavior at a level at least equivalent to punishing negative behavior. There are all sorts of other things, restorative justice programs where you set up kid court, you set up mediation processes so that the kids who have a fight can talk about why they had a fight and why it shouldn't happen again and how they ought to resolve their differences differently. There need to be more meaningful and often better alternative education settings. So if we have to put a kid out of school, at least there's a place for the kid to go to keep learning and keep improving and potentially get back into class. And then we have to figure out a way to take advantage of available community resources at a much better level than we're doing now, where they're available. This is a problem in rural districts, but in some school districts, we have a lot of community resources that need to be tapped to deal with these issues. So that's where we are. I'm told that especially after that long-winded presentation, that it's time for a break. Before we go on to the other 2 points, I'm happy to take a couple of quick questions if you want to right now, but I'll be available for detailed questions at the end. So if not, why don't we take a 10-minute break?
10 minutes, we'll let them.
Hey, good afternoon.
Good afternoon.
I am not Bryant. I think I look better than Bryant.
We do look alike, though, so there you go.
Let me first say, and I shared this earlier, but let me first say, I am just beside myself. I am really honored to be here today. I'm an educator, been in education for about 30 years, product of the DeKalb County school system. Just a little country guy who got an education, started as a band director, and then progressed from there. And I don't know about what you think, but this is huge for me. To be with these gentlemen here, Brad I've known for a long time, and I've been in some meetings with you, I believe, Rob, but I had a chance to be interviewed with the study that you did, and this is just huge for me because all I've set out to do is just try to help kids. And that's the way I got into this business, because I came from humble beginnings myself. Didn't know my dad till I was 23 years old. Didn't live with my mother, raised by my grandparents in the projects. And all I want to do is just try to help people. And that's how I got kind of into this, and it's just big for me. So I thank Barton, and I thank you, Ms. Carter, and Randy. Good to see you again, and all of you who I just want to thank you, because this is really, really big for me. I'm gonna try to stay behind here. I usually like to move around, but I say all that because the whole idea behind student discipline, particularly as it relates to due process, is really more of a philosophy than a process. Because really the goal is just trying to help kids. And when I talked to administrators, and actually I had a training session with administrators in DeKalb County just last week, and trying to get people to move from this idea of, you got to get them, or you got to do something to them, or something of that nature, but you're trying to help kids. And when you look at this, and many of you maybe heard of Maslow and Maslow's hierarchy of need, but he says this, he says, what is necessary to change a person is to change his awareness of himself. And the whole idea behind this is that we got to really move kids into this understanding of self-discipline. In our code of conduct, in the first few pages of our code of conduct, it talks about moving kids into self-discipline. In other words, why do we do, and for lack of a better way of saying it, why do we do right? Because we understand that that's the thing that we should do, and that it's not about that there's something going to happen to me necessarily, that there's something that I'm going to get some kind of penalty or consequence or something of that nature. Is just because it's the right thing to do. And that's where we are as adults. Now, we understand, and Rob, you said some great things, and there's some, I really listen intently, because I'm learning from this also. I'm not just a presenter, but I'm also listening. We got to get kids to understanding. Well, let me back up. We got to get adults to understand that these are children. They're not adults, they're children. If they act like adults, they wouldn't be children. And if you study anything relative to brain research, you've heard about the fact that this part of the brain is not connected to this part of the brain yet. And it doesn't get connected to what year? 25. That this is, in other words, someone shared with me, they have a great accelerator, but no brake. And so when this is not connected, then they do stuff. And have you ever asked a child, why'd you do that? And what they say? I don't know. And we used to get on about the fact that you don't know. But and sometimes, in all honesty, they don't know. A kid, unfortunately, and it's tragic. There was near my subdivision. There was a young man who decided, and I live on a two-way road that's tree lined. It looks very pretty during the winter. Lovely area. And he decided that he just wanted to go down that winding road at 100 miles an hour with no seatbelt on. Now, ask yourself, don't raise your hand, would any of you choose to do that? Or at least if you chose to do it, you say, okay, I know this is going to kill me. But, the whole idea is that you understand the risk. And if you do it, you're going into it hopefully understanding about the risk. Well, sometimes because of this, accelerating no brake kind of thing, sometimes kids are just they're not thinking. That's why you can't get insurance lowered till you're 25. Car insurance. So we got to understand they're children, but we're trying to help them by the same token. We're not excusing their behavior. We're trying to move them to the area of self-discipline. So that's why this says the ultimate goal of disciplinary actions and due process procedures is to change student behavior via the vehicle of self-discipline. We're trying to move kids to understand and do right because it's the right thing to do. Now, that may involve consequences, but it also involves some other things. As Rob talked about earlier, there are some challenges in student discipline. Those of you who work with kids and work with schools, you know now there's a little bit of a distrust now in some cases. I'm probably older than anybody else in here. You have to believe that. You're supposed to say you don't look like it, Quentin. But really back in the day, if the teacher called your parents' house and said to your mama, you know, Quentin's been talking in class, what would mama say?
I'm going to take care.
It will never, y'all take care of Quentin, it will never happen again. Well, if you've been working in some place relative to school, what kind of things do you hear now? You know, ma'am, Quentin is talking to my class. Well, Quentin said that you called him a poo-poo head. And I'm not criticizing parents or anybody. I'm just sharing with you that there's a little bit of disconnection now. Because I shared it, I said, well, ma'am, tell me, where'd you find that information? How'd you get that information? My child told me. Well, ma'am, children do sometimes stretch the truth a little bit, particularly if they think they're going to get in trouble. But what I'm saying is, you see the difference now. Shake your head if you understand what I'm saying. From that mentality. So there's a little bit of distrust, and a little bit. There are parents these days, and I try to tell administrators this. There are some parents who got into a little bit of trouble themselves when they were in school. So they don't necessarily want to come to the schoolhouse, or they have a distrust of coming because they remember when they were in trouble. We were just talking about a minute ago about our DeKalb school system bullying awareness campaign, which I want to put a plug to you. It's been published by the American School Board Journal. Happy to say that. We're excited about it, and we're also presenting that in the conference in a couple of weeks in Callaway Gardens. But the whole idea behind that is we understand the reason why we're dealing with bullying is because people remember being bullied or being the bully well into adulthood, and the consequence and the factors and the impact that's associated with that. So there are parents who kind of have a little bit of distrust. I have parents that come in my office sometimes, they say, well, I don't want my child to go to that alternative school because when I went to that alternative school when I was in school, you see. There also, as you very well know, I don't have any statistics for you, but it just seems anecdotally that, you know, you have mental health issues that are on increase, you have substance issues, things of that nature. Back when I was in school to be in training to be an educator, or particularly in special ed, they used to talk about crack babies are coming. With the onset of crack, and they made it almost sound like a horror movie. Beware, beware, crack babies are coming, crack babies are coming. Like there was going to be this real bizarre behavior that these kids were going to exhibit because they were the offspring of parents who were involved in crack. Environmental, cultural factors, familial, social influences. We talk here about the foster care situation, other factors, group homes. I just talked to a couple of persons from group home today, this morning before I left the office. All those kind of issues, kids being removed from the school, removed from the home, things of that nature. And then interesting, this war, and this is where George Appleseed and others come to play, this war between restoration and being tough. Because I will tell you, there's a faction of people who feel like that any kid who gets in trouble, let me take this off because it's clicking. Any kid who gets in trouble, who disrupts the learning of my child, who's trying to make A's, should be out of this school and never darken this door ever again. Would you believe there's people who feel that way? Okay. Whereas on the other side, you have persons who feel, you know, and rightfully so, that too many kids are getting suspended, too many kids are getting kicked out of school, et cetera, and you can't educate them. In DeKalb, we have a wonderful student attendance protocol, which I'm presenting at another conference in St. Simon Island golf and tennis resort at the end of the month, another state conference. We're happy about that. But we understand that you cannot educate a student if they're not sitting in class. They just do not, it is not the same education. You can give them work, you can have tons of other different things, but the best education is what? That youngster sitting in that classroom getting direct instruction from a competent, qualified teacher. And real actually, I want to go back again to the philosophy. The philosophy is we want to get kids in school. I thank you for talking about PBIS, but we got to get administrators and everybody thinking in terms of how do I prevent things from occurring? How do I plan? How do I make sure we have a supervision or presence? Those kind of things, because when we get into what I'm going to talk about in a second, when we get into this due process part of it, or the hearing process, something has already happened. The real goal, ladies and gentlemen, is to try to do everything you can to not have it occur in the first place. Then you don't get into this war, or you don't get into this battle of philosophies about whether or not you're going to try to keep them in or put them out. Because if you're working to make sure that kids are understanding to do well and to do right, and also knowing where because PBIS deals with this. You look at your data, you look at your hot spots, you look at where those situations are occurring, you look at what types of incidents are occurring. You're looking at, in some cases, what kids you have who may have some challenges. And so then you focus your resources on those children. You look at your teacher situation. You may have a teacher who's writing 500 referrals and everybody else is writing 5. What does that tell you? But you look at all that information, time of day. You look at time of day. You look at, okay, well, seems like all my major incidents are occurring after lunch. I remember one of the schools that I worked in as assistant principal. We knew that we would have our fight situations after third wave lunch, those kids who were taking class on third hall. They come out of the cafeteria, turn left, go up the breezeway, go to the end of the hall. When they hit that corner of that hallway, that's where the fights were. So what do? Do you say, okay, oh well, that's where the fights happen? Goodness. Or do you do something? So what we did, put 2 people right there. So when the kids turned left, went up to the corner, there's 2 people standing there. They want to take it down a little bit down the hallway, boom, there's somebody else. Because and then you work with the kids to say, okay, this is not the right thing to do. You move on. Increase legal scrutiny. There's more awareness even with parents these days about how this stuff works. And some parents know it very well. And along with that, budget issues, because as we talked about earlier, shrinking resources, and particularly as it relates to social emotional learning. Because what's been the focus, ladies and gentlemen, for quite a while now? Well, and basically, if you want to kind of use an umbrella term, instruction. In fact, the last bullet says better instruction, better student achievement. Yes. But what about that kid who comes out of a situation that has a lot of challenges? Take you back to Maslow's hierarchy. What's the first need under Maslow's hierarchy? Psychological or physiological. Okay, what are physiological needs? Food, shelter. Just the fact, do y'all realize, and like it's indicated to you, I came out of the projects. I mean, that's where I came. But do you realize that some of the kids that we deal with, the only meal they're getting is at school? Do you realize that we are dealing with some kids who are facing challenges that some of us will never have faced and never will face? The sad part of watching a commercial a while back in which a mother was stealing ketchup from restaurants, taking it home, putting the ketchup in a saucepan, putting water in it, and heating up as soup for the children. We got kids who live in environments and situations, ladies and gentlemen, that none of us would ever want to live in. And then we are then thinking they're going to come to school and sit there and really focus. I mean, I lost 30 pounds, and so I was trying to stay away from the brownie. Didn't make it. Quite. I had a corner. But do you know what it's like? And how many of you, raise your hand if you've ever had your stomach growl, being hungry? Okay, now here's the tough part. Who in here, don't raise your hand, would have ever known the feeling of having your stomach growling, and you know even when you get the time, you can't get anything to eat? And then try to focus when you haven't eaten for 2 days. Follow what I'm saying? So the idea behind this is we got some real challenges with our kids, and we got to help them be successful. So we want to do the prevention thing. We want to help kids be successful. We want to be planning and all those kind of things. But what happens if a kid does do something that's in violation? Well, I'm pretty sure, because I'm in a room with a lot of attorneys, so I'm not going to try to report. And please understand this. I put a couple of things like the little squiggly thing. Y'all get what I'm... You attorneys are supposed to laugh, because I mean, I'm not an attorney, but I try to do this the right way. I live this stuff every day, and I really try to be legally on point, but I'm not an attorney. So I apologize to all the attorneys in the room if I say or do anything that's out of procedure, okay? If I put a squiggly in the wrong place or put too many, let me know. All of you in here probably can recite Gospels and Lopez in great detail, probably write a whole book on it, right? Gospel and Lopez, relative to due process, that's where we sit as relates to discipline process, due process, as relates to hearings and things of that nature. What some people may not be aware of is Wood versus Strickland, which was also that same year, but also plays a big part. Gospel Lopez is the landmark decision, but Wood versus Strickland also is kind of a companion to that. Gary McGivney me talk about that, by the way. Okay. And just for your knowledge, Wood versus Strickland, if I remember correctly, Wood versus Strickland had to do with some kids who wanted to spike the punch at a school dance or something of that nature, and they talked themselves out of it, but then they finally decided to do it, and they went across state line, got something and put it in the punch, and they got disciplined for it, and it was something, if I remember reading, it was about the fact that the district said that you can't have intoxicating beverages, but it didn't say anything about having alcoholic beverages. And the whole idea behind this was, and all the discussion in the hearings was about whether or not they were intoxicated. Well, nobody got intoxicated. Because this thing had something about, it had the alcohol level of something like wine cooler, ultimately. But now, and we also have the Public School Discipline Tribunal Act. I'm glad to hear Rob say that this is some pretty good legislation in there. And there's several state laws relative to the School Discipline Tribunal Act. So under Gospel Lopez, you have the local informal hearing. I also want to share with you very briefly about something practiced in DeKalb that's called the local formal hearing. Somebody was asking about that just a second ago. And then you have the district level hearing, and then we talked about process for special ed and Section 504 students, includes a manifestation termination meeting. In the local informal hearing, basically that's the administrator and the student. Student has gotten in trouble, violated some rule of school or violated some rule of code of conduct, and so the administrator brings the student in and says, look, Quentin, this is what I understand you did. Now, here's what I want you to do. I want you to get, now this is what I understand that happened, but I want you to give me your side of the story. Administrator allows Quentin to give his side of the story. Administrator says, okay, well, this is what I understand my investigation, so now this is what I'm going to charge you with, and this is what I'm going to give you. Now I'm going to call your parent. Okay? Now, there may be some continued investigation, but with that, the administrator can suspend the student up to what? 10 days. Now, basically, and what we tell administrators in DeKalb, that any type of 10-day suspension, whether that be out of school, in school, but also if there's a bus suspension. But why is that important? I'm glad you asked. If a student is suspended off the bus with the challenges that I just shared with you, what does that mean? They're not coming. They're not coming to school. Yeah, you suspend them off the bus, and you're saying, okay, well, Mr. Rob, I didn't suspend them out of school. I just suspend them off the bus. Yeah, but if it's like my mama, they had no way of getting you to school. So you end up being what? Out of school. Now, this is the requirement under Goss versus Lopez. That's all required to do up to 10-day suspension. Now, in DeKalb County, we have a local form hearing process, and just wanted to kind of share with you why we have that. It's a little bit different. I'm not sure if there's any other school district that really does this, but there's a reason for it. It gives an added level of due process. I just shared with you a minute ago, under Goss versus Lopez, who does the administrator talk to? The student. The parent may or may not be involved. Under our local form hearing process, the parent is involved in that they get an opportunity to review the evidence, question witnesses, get a chance to make a closing statement to a hearing officer. I'll talk about the process in just a second. It clarified, the local form of hearing clarifies the issues of an incident before moving forward, provides parent opportunity to participate and review evidence before moving forward, provides additional vetting of the incident, and it provides consistency. Now, let me back up for a second. Here's the way the local hearing process works with DeKalb County. The local formal hearing process, the case is heard before a hearing officer. This person is not supposed to have any direct knowledge of the incident. But keep in mind, this is not embedded in Goss versus Lopez. This is a practice. The parent gets a chance to hear the evidence. The parent gets a chance to ask questions of witnesses. The parent gets a chance to make a closing statement. The child gets a chance to give his or her side of the story in front of the parent. And the hearing officer makes a decision. Now, here's the thing. We have a local formal hearing when there's a possibility that a student's going to be suspended for more than 3 days. If it's 3 days or less, then the school just gives that consequence. So in turn, before this moves forward to any significant level, because if the hearing officer determines that this child is not guilty of what they've been accused of, that kid is exonerated. Now, again, this just provides an additional layer. It's not in due process, as it relates to Goss versus Lopez, but it's a way of providing additional level. There are some districts that may do something like a review or something of that nature. I'm not really completely sure. I know that one school district that I'm aware of, they kind of had a review before they went to a high-level district hearing. But the whole idea is just giving a parent opportunity. And if the parent disagrees with the decision from the local hearing officer, the parent can appeal. It's not a right, but the parent has the ability to appeal to the principal and then to the area assistant superintendent, who's the principal's boss. Okay? Just something to think about in terms of how due process works. If it gets to a level where it goes to a district level, and you see the codes associated with the district level hearings, and there's also because it's a high level due process, there has to be reasonable written notice. Parents may be represented by counsel, cross-examination witnesses, review evidence. There's a recording of the hearing, whether that's written or electronic. Several school districts now do digital recording of the hearings. And the rationale and the reason for having a district level hearing is to determine whether or not the student is to receive consequences beyond what the school gave. Now, I've had to try to really make that kind of clear with administrators, because the whole idea, and if you look at the statute, it says that it's a recommendation from the principal for long-term suspension or expulsion. Now, keep in mind, this whole idea behind this is giving kids a consequence that helps to do what? Redirect behavior. And let me step in by saying this. If a child has a violation, the whole idea of a consequence, notice I did not say punishment. The whole idea behind a consequence is to redirect behavior, to do what is minimally necessary to bring that kid back around to doing what's right. Everybody follow me? Now, here's a thought. And you tell me what you think about this. Is the intent of suspension and having hearings, is the intent to redirect a student towards self-discipline, or is the intent to send a message to the other kids that we ain't taking it? Well, if you want to throw that in there. Yes, ma'am.
I don't think it's redirected the behavior. The child is being, or she has they have consequences, but you have not redirected that behavior. The behavior may stay the same. They may not do it again, but you have not given them good choices. You have not dealt with what the issue was, in the sense where does it need redirection? Does that make sense?
Yes. Now,
Would you mind repeating the question since we weren't able to catch it on the mic?
Okay.
Please.
The question is the intent of providing consequences, whether it be out of school suspension, in school suspension, whatever consequence, and the whole idea behind having hearings and things of that nature which are tied to giving consequences, is the intent to redirect student behavior and bring them to a level of self-discipline, or is the intent to send a message to the other students that we're tough and we're not going to take it from you, and if you do something like this, you're going to get exactly what they got? What's your thought? Yes, sir. Yes, ma'am.
I think it's to send a message, but also I think that I'm not sure that it's individualized, the consequence, because sometimes, you know, it depends on the situation and how many times the child is guilty of committing such crimes in the school or behaviors in the school. So I think it's more I think it's both, really.
And we've already spoken, so you know my bias is for parents and the students, but I do hear from a number of parents with different levels of resources, and they do feel like they're being punished when their child is being long-term or subject to long-term suspension. They can't even hire me to do a flat rate tribunal for them. And so, you know, if they can afford a private school, those kids wouldn't be in those schools to begin with. They need to work, so they can't homeschool. And, you know, if the child isn't under an IEP or a 504, they're going to have to find their own transportation to the alternative school.
And then I would have questioned what has been done to bridge the gap with school boards, school systems, and agencies such as DFACs and organizations like that, oftentimes they may send representatives to the various form of hearing and do not get an opportunity to have a voice to speak in your tribunal hearings and things of that nature. And it's evident through stats that our kids in foster care are suspended with out-of-school suspension as well as in-school suspension at a very much higher rate than oftentimes other kids are. So I would ask you the question, what is the intent? Because seemingly it is to send a message. And unfortunately, you know, if I would have youth in group home settings, if one comes back, oh, I got thrown out of school, or I'm sent to the alternative school, stats would easily show with some of the schools, even here in DeKalb and some of the group homes here in DeKalb, that a number of the youth in that particular group home setting are matriculating now in alternative school settings. So again, I would ask the question, are you starting to send a message? Because seemingly, you know, the stats kind of show for what is going on.
The rationale, the reason for asking that question is, again, this whole idea of what I shared earlier about philosophy and changing this dynamic to, as you indicated, about individualizing and being able to and being able to articulate and defend what you are doing as an administrator, as a teacher, as a district level administrator on every single child. Because the whole idea is, and I will say to you, the whole idea, there's two things that come to play in my mind with every kid. The one is helping this kid to move towards self-discipline, and if the kid has done something wrong, providing an adequate and appropriate consequence for that child. But the other is, what is the best thing to do concerning help them with their education? If they're behind, then what can we do to help them get caught up? Things of that nature. So I'm with you. Yes.
One other, I guess, item I'd like to bring up regarding showing kids, you know, what's going to happen to them when they do it. The thing is, in tribunals, and I do represent students primarily with disabilities in tribunals, that cards are stacked so high against us. We can't compel witnesses. Most of the time the decision's been made before we even walk into the building, because it doesn't matter what we say, what we show, the kids are found guilty. No matter what the evidence is, the decisions are made. Then they put them in the alternative schools, and there's no effort made to teach them alternative behaviors that are more appropriate. So it's all about showing the kids who's boss and what happens when they misbehave.
I just wanted to piggyback on that, and also what she was saying is, after teaching in California for 18 years and 2 out here in Georgia, it's part of the job as a teacher is you find out what your children's backgrounds are. So you automatically, I always did, individualize in that respect, knowing that one of my students slept on the floor. He had no place to do his homework other than if he locked the bathroom door. And again, did not have food during the weekend. Only ate at school breakfast and lunch. He was on free and reduced lunch. But there's so much that I would take as far as his misbehavior versus another student that there were no excuses as far as that goes. So I would look at each student individually and go accordingly. That's why after all, I think I only had one student perhaps that was suspended and sent to an alternative school, and that was out here in Georgia, and that was because he threatened to kill me and, you know, burn the school down, etc. And that was something that needed to be dealt with. But also I looked at, before I made any motions towards that and enforcing that, I thought there were other things that had led up to that decision, because I knew what his background was. I knew he was in a single parent home, and he took his parents' divorce very, very hard, didn't see his father. I mean, there were just various factors. So that was something that I took into account before I went ahead and pursued that last step within the classroom. And there's a lot that I think you in education understand, that as teachers, there are certain things that we just tolerate. And that's what I always did. That's just something that you did because, again, the individual child.
And again, I go back to the question, what are we doing to bridge the gap between child welfare agencies and boards of education, administrations in the school systems? Because as the young lady suggested, seem like the decisions are made, it's just a process. The hearing process is just that, a process. The tribunal process is just a process. It may not be to the child's advantage to have the parent speak. Well, because the child's in de facto custody, the state is the parent. And then it may not be the best interest to have the case manager speak because me as an advocate, maybe I should speak. Well, then it may not be the best interest for me to speak because the therapist may need to speak. But the process, one person speaks, and then we're going to tell our side of the story from the staff of the school is going to present, and then the decision is sent to the office with the decision that I would suggest has been predetermined. So what do we do again to bridge that gap between child welfare agencies and school systems?
Okay.
Or is it just a process?
Okay. Well, and just, Rick, because I know my time is waning here, but let me just answer that question. First of all, we need to get together. And that's one thing I've been asked to do with some of the new administration with DeKalb, is to reach out to child advocacy and other agencies, and I already do that to a great extent because I work with a lot of agencies now. But to reach out to child advocacy agencies and so on and so forth, because we're all supposed to be on the same page, and that's for the benefit of the kid. Now, I will say to you, and I can't speak for other school districts, I'll only speak to, because I know our process. And one of the things about our process, particularly with our tribunal, is that they don't know anything about the case. They don't meet before the case, so they don't know anything about it, so they can't stack the deck and they can't make a decision on it before it happens. And for the past few months, since I've had to be directly involved and be in the hearings myself as a school system representative, and I take that to heart, they don't know anything, and I don't share anything. And so when they come in, they're a blank slate. They don't know anything. They're hearing everything for the first time. Now, so we're going to I can't speak for anyone else, but the idea of the process is that it's supposed to be fair. That's why you have process. No. You're talking about the tribunal. No. They in DeKalb County, they rotate every day. So there's a new panel every single day. And so they don't know what cases are coming up. So I understand that you refer to the process. The process is designed to be fair. But now you can have perfect processes with imperfect people. And so what we got to do is kind of work to make sure that everybody has the same philosophy again. And that's what we're trying to do, is to help kids. And that's why I raised the question initially, is that, and I'm saying this of educators, what's the idea? What's the intent? Is the intent to redirect misbehavior and go towards self-discipline, or is the intent to send a message that we're going to be tough, as we talked about earlier? That's the whole idea. And I'm just raising the question because those are the kind of things that we need to talk about. If we're going to help things to get better for our kids, these are the kind of things we need to talk about. Let me finish up very quickly. This is just definitions under the state code about expulsion, long-term suspension and short-term suspension. And for a lot of people, they think about expulsion as being put out, but under the Georgia code, expulsion is any suspension longer than 1 quarter a semester. As Rob said earlier, not sure there are really a lot of permanent expulsions, things like that in the state of Georgia. Is that what I heard you say earlier? Permanent expulsion, very rare. Okay, because the whole idea is trying to, if a kid needs some type of long-term suspension, at least try to do progressive discipline and try to put them in alternative school as much as possible. Lastly, and this is going to segue over to Bryant. On the district tribunals, if a parent or guardian disagrees with the decision from the tribunal or hearing officer at the district level, then they have 20 calendar days to appeal that decision. And the appeal under the statute is a review of the record. Now, there may be districts that do this a little bit differently than others, but bottom line is a review of the record of the hearing that was held. And if the parent disagrees with that decision, they can appeal to the State Board of Education within 30 calendar days, and then to the state superior court within 30 calendar days from the state board's decision. And as I said, each school district may have a little bit different process on how they accomplish that, but these are the timelines and the procedures that are given by state code. Lastly, I just want to say to you simply this. First of all, I am, again, honored that I was allowed to come and speak to you today. I am really concerned about, well, I can speak for my position in DeKalb. Been doing this a long time, but I never say that anything that's being done cannot be made better. Because as I said to you earlier, what's the real goal? What's the real intent? The real intent is to help kids. And so that's why we got to work together. That's why I welcome the opportunity to interview with George Appleseed. And in fact, I shared some of your information with one of our new bosses. And the whole point of this is working together so all our kids can learn. We got to keep schools safe. And for those significant issues that occur, we've got to deal with those. But make sure that's the reason for what's happening to a kid and not just cause I got to get somebody. Okay? I thank you very much for your time. Thank you for listening. Mr. Brad Bryant.
Quentin took a little bit of what y'all probably should have delivered my way, so thank you, Quentin, for that. And that I know that definitely is not a problem, because I've been doing this 20 years. I did 12 years on the local board in DeKalb County, and 8 years at the state board level. The entire time I was on both of those boards, I was the only attorney. And I've probably been to 2,000 meetings in my life, so I've had my share of arrows shot my way, and have learned to embrace them, love them, and actually see great value in this. And I think that last the last questions and comments really are where we should be in the value of a process like this. So I too want to express my thanks to Barton for doing this, because these conversations are long overdue, and I think that only good things will come about. What I want to do with the time I've got is I just want to put up a couple of slides that really give you the nuts and bolts. Many of you may already be familiar with this. Quentin covered the procedural side from the local board perspective, and I'll talk a little bit about some of the challenges that I think you face with local boards and that local board members face as they go through the discipline process. But just to give you, for those that have not had appeals to the State Board of Education, first you should know that your State Board of Education is appointed, not elected. It's appointed by judicial district, so we currently have 13 state board members from around the entire state, and soon to have a 14th board member. The appeal actually comes from any matter that is a local controversy. So probably the best example that I could give you of something that would not be discipline related or teacher termination related at the local controversy was several years ago. Harry Potter, there was a parent who wanted Harry Potter books banned in Gwinnett County media centers. That she went through the process at the local level, and that actually came to the state board level. That happened to be one of the things that America Online and the national media saw great value in. Not any of the instructional issues that go on, but and we had many in the media who were sorely disappointed when they found out that it was a appellate hearing, and that all we would do as a board would be to vote yes or no. We found any evidence to support the decision at the local level. The appeal must be filed with a local superintendent, so any appeal that you have from a discipline case at the local level actually filed with the local superintendent, and then the local superintendent transmits the record within 10 days thereafter. You can find the state board rule at the department's website, www.gadoe.org, which is down below. It comes, and again, it's not a de novo hearing. The appeal shall be confined to the record. So your state board actually sits, as does the Superior Court from which a state board decision can be appealed, sits as an appellate body. There is an opportunity for an oral argument. I'm not sure, particularly those of you who represent parents, I'm not sure how much value the oral argument adds to the process, because many times it's still that parent looking for an opportunity to have what they believe would be a more objective body have an opportunity to state their case once again. And unfortunately, for that parent, in a situation that is not de novo but appellate, there's not anything that hearing officer at the state board level or the state board can do if it's not already within the record. Following that, the state board, which meets, the state board is trying to meet not on a monthly basis as much as trying to offer an opportunity to have a 30-day window between state board meetings because of what's required in the policy making side, which is that all the decisions will be posted and there ought to be an opportunity for comment on 30 days. But roughly there would be 10 to 12 times a year that the state board would meet and hear the appeals that would be brought by in a draft form by a hearing officer. And once that decision is rendered, then it has to be delivered in a written form to the parties. I learned on this past Friday when we gathered some stakeholders together, you don't know how excited I am to have all decisions from 1974 in a single site on a website. But that excitement was tempered by the fact that it's not in a very user-friendly search engine. So that is on our, hopefully on our list to do, is to try to make sure that if you want to access any case that has been decided from 1974, that you would have an opportunity to do that in a better search engine. And then there's an opportunity to appeal that decision from the state board to the Superior Court in the county wherein the local Board of Education is situated. That's kind of the nuts and bolts, and if you've got questions, feel free to deliver them my way. What I wanted to do with the rest of my time is just to talk to you about, I guess my world would have been where policy meets practice, and some of the observations and some of the challenges that I have seen in 2 decades. And I wanted to pull back up 2 of the slides that Rob put, because I think that they set that context really well. If you look at this particular picture, those of you who have ever been around a tightrope or on a tightrope, there are a couple things that go into how easy it is to walk along that tightrope, and I think it speaks to some of the comments that I heard and the questions that were raised. The farther apart the 2 poles are, you end up with more of flexibility in the tightrope. And so if we look at the individual that's on this high wire as being one of our students, the farther our child welfare and our education community is, the less likely it is that that student will be able to stay on that tightrope. The farther our policy folks are from our practice folks, the less likely it's going to be that we've created, however narrow that wire may be, we've created the actual the lack of tension that would allow that student to be on a very shaky wire. If you couple that with the fact that we actually have folks on both ends of the tightrope who take great comfort and joy in stepping down on that wire and creating that instability, what you get a picture of is how, as adults, and I would argue that any of us, wherever we come from this, have some level of unclean hands in terms of our ability to do better by children, and that may present itself in our unwillingness to sit down and be open to things that we've done for many ways, in the same ways for many years. The actual biases that we build in over time. And so I think all of that is just to suggest that what happens. If you also look, you will see, and I didn't realize it the first time, Rob, that this flyer on the tightrope actually has a safety latch. And so I would argue that one of the things that we can do better as adults who serve children is to try to think about what are those safety latches or cords that we can put so that if that 18-year-old boy who does not make good decisions because the brain has not been fully connected falls off of that wire, they don't fall to a place where we can't get them back up on the wire. So I thank you for that, that picture. And then back to the point of how this is truly a balancing act. And that whether you come at this from the standpoint of the rights, the individual rights of the student to, or the collective rights of the group, what we need to always do is to try to stay in the middle and see if we can balance that. So some of the things that I would just, my observations of what I've seen as first a local board member and then as a state board member is that unlike any other elected position in the state of Georgia, when you elect a local member of the Board of Education, you're electing someone and you're charging them to perform both all three of the functions of government: executive, legislative, and judicial. And trying to give you an absurd result is that, and Quentin and I spent time around Dunwoody High School when he was on staff there. It would not be uncommon in Georgia to see someone run for the state, for their local board, because they were upset with a decision that the community made to fire a football coach. And what I've said is, what if you were able on the first day you were sworn in to get rid of that football coach, hire a new one, what would you do for the remaining 3 years and 364 days on your term? A lot of folks don't think beyond that, and then they're thinking more in their legislative function rather than ever realizing that they would have to hear teacher termination cases, student discipline cases, and perform some of the executive functions. So all of that is to say that we have 180 local boards of education, plus the DJJ, which is convened as a local board. We have over 1,100 board members locally elected in this state, and every one of them comes at the work differently. So we have a lot of moving pieces, and so when you step into a particular county or local school district, you're stepping into something that may be different if you step into the county or the district next door. So one of the things that that I would argue that we've got room for improvement on is trying to look at how we can more adequately train local board members with respect to the judicial function. And that would be both the procedural side of it in terms of the mechanics that would be attached there too. And then really, if you think about those of you, and with Sharon Hill here, when she would have gone in to the juvenile court work, there would have been a whole battery of opportunities for her to do professional development around what would make a better judge. How you have the discernment, how you have the temperament, how you work towards impartiality, and how you take facts and you apply them to a code of conduct. And the code of conduct would most likely be a single code of conduct rather than 180 local codes of conducts within the state. So there's an area where there is a huge room for improvement. And the challenge to all of us is that we are a local controlled state. And so anytime you would raise this as a concern, you're sure to get pushback that we know what's best when we elect our local officials. Which gets me to the next point, is that when there is a case that becomes disruptive within your community, something that is egregious, what generally happens is the community rises up, and these elected local board members have a couple of things going on. Is one, they're inundated in some cases with the media attention that comes along with that. And then the other thing that happens is that they're thinking, I've got to run for office again at some point. And so that becomes not the right way to approach it, but it is the reality within which we deal with. All too often in DeKalb County, what I would hear from folks is that we don't want to refer this child to the juvenile courts. What we'd rather do would be to have the school system mete out whatever the punishment was, which goes and is contrary to what Quentin said, is that if the focus of the educational system is to try to help that student become a better student, more focused, and a better learner, then if we expect within our communities for the school system to kind of slap the child on the wrist rather than putting them into a more formal juvenile process or into a criminal process, or even in some cases you'll have parents or teachers say, well, I won't sue the child civilly or the parents of the child if you'll do this. I would say that diminishes the overall intent. You have the flow and pace of disciplinary actions. I probably spent more time soaking in a bathtub reading student discipline transcripts in my time on the DeKalb board, and I don't know how many you have referred currently, but I would imagine that our board handled 2 to 3 every week, which meant within the context of the local setting, that meant that we would have to meet on a more regular basis than what the stated meeting cycle was, because we had to dispose of these cases within 10 school days, I believe. So you've got that flow and pace for some of the larger districts where you've got some parts of Georgia that may not have a discipline case that pops up, but on the rare occasion where it would go to a formal decision. And then the status of students under IDEA, and there brings in, for me, the whole the crash of arguments, because on the one hand, you would have the folks that work with students under IDEA saying it's not fair in the process, and you've got everybody else who thinks that it's potentially unfair, that the student will end up with the local board making a decision, but then the student returns back to the IEP process to determine whether or not the consequence of that action was a manifestation of their disability. And so what you have is you basically end up with there being, because of a lack of understanding within the community, you end up with a lot of frustration, because the child who might have been a ringleader in a group escapes in the mind of the rest of the parent community a consequence when in fact the student is just going through an alternative process to determine what those consequences would be. And the function there for the board is to determine whether or not the facts as presented did in fact take place. And then the legislative mandates, and I know Rob said it's a pretty good code, but what I would ask you to do when you get a chance to look at it is, I get a little bit nervous when I see a code section and then you see point 1, point 2, point 3, point 4, point 5, point 6. That generally means that the legislature has come back in, opened it up, and figured out how they're going to fix something. And as it relates to 20-2-751, which deals with how a state board and what a state board should do, what I would just say is that we added a provision for weapons. We added a provision to honor decisions from other districts. We added a provision on bullying. We added a provision on school bus conduct. And then we added a provision on physical acts against teachers and other staff members. We did that from the period 1995 to 2010. And basically what we could all do would be to go and we could trace back to a specific instance that took place that got the legislature's dander up sufficient to where they came in and they said, regardless of whether we want our local districts to have the full faith and credit, we think we know best on that particular issue. So we're going to be more prescriptive in terms of how Quentin and his team would work on a potential issue. And I would just say over a period of time, what ends up happening is there are more exceptions than there are rules. And what happens is you end up with some of that distrust that comes out of a process that does not seem to be fairly implemented. And then I don't want to suggest that there are good parents, bad parents, parents that understand it, parents don't. What I would just say is that there is an uneven parent engagement in this process, and what we've got to figure out is how to create higher levels of engagement and better engagement and create, because I think a lot of Rob's data could probably be traced back to access of parents, whether they knew they could access something, whether, and some of it is just what Quentin said of parents that had bad experiences with during their school time are going to be less likely to engage in the process as well. And then the notion of the community and cultural expectations related to discipline, and with 180 districts and with schools within those 180 districts, we probably can find patterns where some would embrace the notion of using higher quality alternative education options, and some would just come at this saying, if we can get these kids out, then those kids that want to learn are going to do that. So those are some of the balancing issues that I see at the local board, and then I'll share with you the state board, and then that ought to give us a couple of minutes for questions. Probably the biggest challenge between the state board and the local board is that for our state board members, there's a tendency without sufficient training to want to come in and want to be the trier of fact. I think that's just human nature. And so what I observed with my fellow state board members was sitting as an appellate judge is a different concept than sitting as a district level or a trier of fact. What we tried to do, and we realized that this probably doesn't work well for you on an individual basis, but what we would try to do as a state board was not use the cases that were brought to us through a discipline process to change the policies or to react negatively to what we saw as gaps within the state law, arguing instead that it should be done through the proper legislative processes. There is the flip of what would happen at the local board level is that there's a pretty strong lack of awareness in the public over what the role of the State Board of Education is. And given that appointed nature, rarely, if ever, did we hear from parents, and if we did, or advocates for parents, if we did, it was similar to the fact that I would no more go down to the Supreme Court of Georgia or the Court of Appeals or to the well of the legislature and just say, I've got a right to be heard. And I think that when the state board sits as in its discipline or its teacher termination, it really is sitting as a court. And then there is a fine line, that balancing act between the role that the state board and the local board enjoy in terms of trying to make sure, and the best solutions are going to be long-term, and they're going to be policy-driven. So there is always kind of a little bit of a tension between Quentin thinking that the state board or the State Department of Education is coming down hard on him, and all I would suggest is that that judicial function makes the water a bit murkier. I touched on the flow and pace at the state level, and then the same concerns would be present at the state board level in terms of getting state board members comfortable with the fact that the only issue before us as a state board would be that students, whether or not the facts as described took place, and not ultimately whether or not there would have been a consequence that we would agree or not agree with. I think those probably are the balancing and acts that are going on. And one of the things that, to answer the question, sir, about, I think this is the first time that I've been aware of in my 2 decades that there has really started to be bringing down the silos between local and state, trying to figure out what can be done better. And then I would argue that that same thing is starting at the state level in terms of child welfare, the court system, and the Department of Education having that. Hopefully, we cannot have too much of that dialogue. I'm probably more optimistic than Rob in terms of I think we're going to agree 95% of the time once everybody has an opportunity to air out what's going on. So I certainly do not shirk from the ability to step in and have the discussions. And even as we sat and talked about this last week, the key issues that came up probably are the same issues that each of y'all would bring collectively to this. And so if we can just identify the issues that are out there, start to have the discussions, I think that we may find solution pathways that we previously have either not looked for or didn't believe possible. So with that, if there are questions or two, I guess of any of us, we'll be happy to answer them and stay behind a little bit too.
Thank
so
you.
Questions?
We are past the original set time, but because we started late and our speakers are willing, I think we probably do have time for 1 or 2 questions, but I'll keep it limited to that out of respect for everyone's time. So if anyone has a pressing question, we'll be happy to take it. I guess you've answered all the questions. Okay, well, since we've stumped the panel, please join me in thanking all of our presenters. I think you'll agree this is a high-quality program.